What if I told you one woman stepped into a routine hearing and walked out shaking the very foundation of authority? This isn't just a courtroom battle, it's a masterclass in knowing your rights, owning the room, and refusing to back down when power overreaches. Pam Bondi had walked through the polished glass doors of the Hamilton Corporate Arbitration Center more times than she could count. Nestled in the heart of downtown San Francisco, the building pulsed with corporate energy. Legal teams in sleek suits, clerks with too many folders, and executives pretending not to sweat. For Pam, it was just another arena. Today's hearing was scheduled in Arbitration Room A, a space she knew well. The matter was listed as a simple compliance issue under Corporate Code Clause 17A, an outdated provision dealing with municipal property boundaries. Nothing urgent, nothing high stakes. She'd reviewed the file over a late-night espresso, flagged 2 inconsistencies, and assumed the morning would be routine: show up, clarify the facts, and leave. Her role wasn't defense in the traditional sense. She was appearing as a legal compliance consultant for a boutique firm, advising them on how to contest an allegedly erroneous violation. No jury, no headlines, just procedure. The room buzzed softly as others filed in, a few nodding in recognition of Pam. She took her seat at the respondents' table, crisp notes in hand, posture relaxed but alert. Across the room, a man adjusted his tie, the city's lead corporate counsel, Martin Shaw. He glanced at her briefly, offering a neutral nod before checking his watch. Then the door opened, and arbiter Malcolm Crane entered. Instantly, the air tightened. Tall, with silvering hair and a reputation for curt decisions, Crane was known for efficiency, but also for leaning hard on the side of institutional authority. Pam had argued in front of him before, never quite trusting his smileless rulings. Still, this case was too simple to worry about. Or so she thought. Crane didn't even sit before speaking. This tribunal has reviewed the submitted documentation. A violation of Clause 17A is confirmed. The fine is set at $10,000 effective immediately. No opening remarks, no evidence presented, no opportunity to speak. Pam's pen paused above her notepad, hovering mid-sentence. Her face didn't change, but her mind clicked into another gear. That wasn't a decision, that was a declaration. And it wasn't just fast, it was personal. As the room fell into a strange hush, Pam slowly folded her hands and looked up at Crane. This wasn't going to be just another hearing, not anymore. The words hung in the air like a gavel that had already struck. $10,000, effective immediately. No preamble, no invitation to present a case, just a ruling, cold and absolute. Pam Bondi blinked once, the only outward sign that something had gone off script. Around her the room shifted, shoulders straightened, glances were exchanged. Even Martin Shaw, the corporate counsel across the aisle, looked caught off guard. Arbitration hearings, especially ones over compliance issues like this, followed a rhythm. Open the floor, hear the evidence, allow rebuttals, and then, only then, issue a judgment. But Arbiter Malcolm Crane had just skipped every step like they were irrelevant formalities. He'd ruled as though this was a sentencing, not a discussion. Pam let the silence linger for a moment longer before speaking, her voice low, calm, and unmistakably firm. With all due respect, Arbiter Crane, I haven't yet presented a defense. Surely the tribunal hasn't reached a conclusion without hearing the full argument. Crane didn't flinch. The documentation is clear. The violation is self-evident. There is no need to prolong this proceeding with unnecessary commentary. He sat down then, folding his hands as if to say, "That's the end of it." Pam inhaled slowly, eyes narrowing, not in anger but in calculation. This wasn't efficiency, this was control. Crane wasn't simply moving fast, he was making a point, and that point had a target. Her. She'd challenged his rulings before, successfully. It hadn't gone unnoticed. This hearing wasn't about Clause 17A, it was about leverage, about setting an example. She leaned back slightly, schooling her face into something unreadable, but inside the strategy was already forming. He'd drawn the first line, but he'd done it without armor. If the clause is as clear as you suggest, Pam said, now louder, measured, then I'm sure the tribunal wouldn't mind if I clarify the record, if only to reinforce the integrity of your decision. Crane raised an eyebrow, the flicker of a smirk trying to form but never quite making it. "You may proceed," he said, but the challenge was unmistakable. It wasn't permission, it was bait. Around them the energy shifted again. Legal observers in the back leaned forward, sensing the rules of engagement had just changed. A tribunal meant to be procedural was becoming adversarial, and Pam, she thrived in that space. She reached for her folder, not because she needed it, but to make a point. "Then let's begin with the wording of Clause 17A, she said, voice cool as steel, "and why its so-called clarity has been legally questioned for years." Crane had opened the match with a move that was meant to end it before it began. What he didn't know, or perhaps had forgotten, was that Pam Bondi didn't play defense, not when the stakes were justice, and certainly not when someone tried to shut her down before she'd said a single word. The ruling was premature. Now, the fight was personal. Pam stood slowly, gathering her notes with the calm precision of someone who knew exactly where the battle lines had been drawn. Arbiter Crane may have thought his preemptive ruling had closed the case, but what he had really done was light the match, and now Pam intended to burn the foundation of his argument to the ground, methodically, legally, and publicly. She stepped forward, heels tapping lightly against the marble floor, then paused beside the respondent's table. "Clause 17A, she began, her voice steady and crisp, states that a violation occurs when a property or entity fails to comply with a regulatory directive issued by municipal review." She turned to face Crane fully. "That language may sound definitive, but definitions require clarity. And clarity, Your Honor, is exactly what this clause lacks." She opened the first document in her folder, not because she needed it, but because optics mattered. "In the past 5 years," she continued, flipping a page with dramatic precision, "Clause 17A has been cited in over 30 compliance hearings. Of those, nearly half were overturned due to its vague construction, particularly Section 3C, which fails to define what qualifies as a regulatory directive." A murmur stirred in the back of the room. Pam's delivery wasn't emotional, it was surgical. Her words were tools, and every sentence was a scalpel. Let's also not forget Hendricks v. Bayview Council, where the appellate court ruled that Clause 17A could not be enforced without clear, documented evidence that a directive had been issued and received by the respondent, neither of which happened here. She glanced at the tribunal table. Crane's expression was unreadable, but his stillness said everything. He hadn't expected her to come this prepared. She turned another page. "Then there's Morales v. Civic Holdings, where the court found the clause constitutionally insufficient for enforcement due to lack of procedural guidance. A ruling that to this day remains unchallenged." Pam didn't look at her notes now, she looked straight at Crane. "So you tell me, Arbiter Crane, is the clause really that clear?" The question wasn't rhetorical, but it didn't require an answer. Silence returned, heavier this time. The observers were fully alert now. Even Martin Shaw, the opposing counsel, sat forward slightly, as if reconsidering which side he was on. Pam leaned in, just enough to make her presence felt. "This isn't commentary, this is context, and without it, a fine imposed under Clause 17A isn't just questionable, it's indefensible." Crane let out a slow breath, folding his hands. "You've made your position clear," he said tightly, "but precedent isn't always persuasive." Pam allowed a small, knowing smile. "No, but it is binding, and unless this tribunal plans to operate outside of established case law, I'd say we've only just begun." She returned to her seat, never breaking eye contact. The gloves were off, and everyone in the room knew it. Arbiter Crane's jaw tightened as Pam returned to her seat, but he didn't respond right away. Instead, he leaned toward the clerk and murmured something under his breath. Moments later, he tapped his gavel once, briskly. "This tribunal will recess for 15 minutes. Pam didn't move. She knew exactly what was happening. Crane wasn't regrouping. He was recalibrating. She had forced his hand with airtight precedent, and now he needed backup. The room buzzed with low murmurs as attendees filed out for coffee or conversation, but Pam stayed seated, flipping idly through her folder, though she wasn't reading. She'd seen men like Crane before, used to being the final authority unchallenged, But when the system cracked, even slightly, they called in reinforcements. And sure enough, when the tribunal doors opened again, Crane didn't walk in alone. Behind him was senior arbiter Eleanor Reyes, a highly respected figure known for her icy precision and deep loyalty to the institution. Her presence was like a cold wind, calm but undeniable. The observers quieted instantly. Pam watched her approach the bench with slow, confident steps. This wasn't protocol. A senior arbiter joining mid-hearing? That was strategy. For the record, Crane said as he resumed his seat, I've requested that Senior Arbiter Reyes sit in on this matter for the sake of procedural clarity. Pam lifted an eyebrow but said nothing. She didn't need to. Everyone in the room knew this was an escalation. Reyes folded her hands on the bench, her gaze locking onto Pam with polite disinterest. Ms. Bondi, she said evenly, you've raised serious concerns about the enforceability of Clause 17A. But are you aware that a follow-up ruling to Hendricks v. Bayview Council allowed for localized judicial discretion in certain applications of the statute? Pam nodded slowly. I am. And I'm also aware that in that same ruling the appellate court required that any such discretion be exercised with evidentiary support and clear standards of enforcement, neither of which are present here. Reyes gave a slow nod, acknowledging the point but not conceding it. Then let's clarify the enforcement, she said. The municipal officer who issued the violation is present. Would you like to cross-examine him? Pam hadn't expected that, but she welcomed it. If they wanted to play formal, she'd give them formality, on her terms. Yes, she replied, rising to her feet. I would. This hearing wasn't about a violation anymore. It never had been. It was about testing limits, hers, theirs, and the very system Crane and Reyes were trying to protect. And Pam had just been handed her next opening. Pam rose from her chair with the composure of someone who had been here before. Not in this room, perhaps, but in this exact moment. The pivot point where a hearing became a reckoning. As she approached the witness stand, the courtroom quieted. A man in a crisp municipal enforcement uniform stood and made his way forward. His name was Ethan Markell, the officer responsible for issuing the violation that had triggered the entire hearing. Mid-40s, clean-shaven and projecting the confident detachment of someone used to being believed without question. He took the oath with ease and settled into the chair, folding his hands in front of him. Pam offered a polite nod before stepping into position. Officer Markell, she began, her tone respectful but exacting. Can you confirm for the record that you were the one who issued violation code 17A on the property in question? Yes, ma'am, he replied smoothly. And when you issued that violation, did you provide any photographic documentation to accompany your report? Markell hesitated for half a second, just enough for everyone to notice. No, ma'am, it wasn't necessary. Pam raised an eyebrow slightly. Not necessary? Based on what? Markell straightened in his seat. I've worked enforcement for 13 years. I know what constitutes a violation when I see one. Pam paced slowly, hands clasped behind her back. So, to be clear, you didn't take photos, you didn't file a written statement from a witness, you didn't gather any physical or visual proof to support your claim. He frowned slightly. I submitted my standard report, which includes my direct observation. That's standard protocol. Pam stopped and turned toward the bench. Your Honors, she said, her voice now raised just enough to pull the full weight of the room toward her. What we have here is a fine imposed on the basis of one man's undocumented observation. No supporting evidence, no independent verification, not even a time-stamped photo. She gestured lightly toward Markell. And while I do not question Officer Markell's experience, the law does not grant immunity based on tenure. Reyes's expression remained neutral, but Crane's jaw tensed visibly. Pam turned back to the stand. Officer Markell, are you aware that the appellate clarification to Hendricks v. Bayview Council specifically states that municipal discretion must be paired with evidentiary documentation in order to meet minimum standards for due process? Markell opened his mouth, then paused. I've heard of that ruling, he muttered. Pam's voice was crisp. then you'll know that failing to include such documentation opens the city, and by extension this tribunal, to legal challenge. In fact, the appellate court referred to fines imposed under those conditions as procedurally defective and constitutionally vulnerable. She turned back toward the panel. This isn't just a flaw in process, it's a disqualifier for enforcement. The room was silent, electrified. A few attendees exchanged looks, eyebrows raised. Even Martin Shaw, the opposing counsel, sat with his fingers steepled in front of his mouth, no longer interrupting, no longer so sure of his footing. Pam stepped closer to the bench, lowering her voice for emphasis. If this tribunal allows this fine to stand without evidence, it will be setting a precedent that words, without proof, are enough to penalize citizens and businesses. That's not discretion, that's unchecked authority. Crane tapped his pen against the bench, his grip tighter than before. Reyes leaned back slightly, her silence more telling than any verdict. Pam had taken their procedural weapon and turned it into a legal vulnerability, and now, with nothing but logic and law, she had just dismantled the entire basis of the case. And she wasn't done. The air was heavy when Pam returned to her seat, the silence in the room thick with consequence. The tribunal had been maneuvered into a corner, but Arbiter Crane wasn't the type to yield easily. After a long pause, he leaned forward, voice tight. While the tribunal acknowledges your argument, Miss Bondi, the core issue remains unchanged. This body retains discretionary authority in matters of municipal enforcement. Therefore, the fine stands. The words landed like a slap, sharp, deliberate, and almost defiant. Pam didn't flinch. She simply turned to the court stenographer. Would you kindly read back the last ruling for the record? The stenographer, quick and composed, repeated Crane's words verbatim. When she finished, Pam rose to her feet again, this time slower, more deliberate. She faced the tribunal, not just Crane and Reyes, but the entire room. Her voice was cool and composed, yet unmistakably firm. Let me make sure I understand this correctly. This tribunal is asserting on the record that a financial penalty may be imposed without evidentiary proof, based solely on an enforcement officer's undocumented observation, despite established appellate precedent that explicitly prohibits this. Her words struck with surgical precision, not as an accusation, but as an invitation for accountability, the kind that stings worse than blame. Crane's fingers drummed once on the bench. This tribunal is within its rights to interpret discretion as applied under the clarification to Clause 17A. Pam smiled, not out of amusement but understanding. Discretion, she echoed, not immunity. She turned to address the room. Because let's be clear, if this ruling is allowed to stand, then what we are saying, right here in a public legal setting, is that proof no longer matters, that an officer can issue a fine based on nothing but assertion, no photo, no statement, no accountability, just their word. She looked directly at Crane now. That's not discretion, Arbiter Crane. That's erosion of due process, of precedent, of the very legal system we're meant to protect. The room was still. Even Reyes sat straighter, her lips pursed in thought. Pam continued, her voice softer now, but no less pointed. The Constitution, state and federal, demands due process. That includes the right to confront evidence, and when there is no evidence, there is no process. There's only power. Crane's jaw clenched, but he said nothing. Pam stepped forward. And what happens when the next person doesn't know the law like I do? When they can't cite precedent or challenge vague rulings? Are they expected to pay the fine, simply because a tribunal says so? She let the question hang unanswered, before adding, because that's not justice. That's convenience. She paused, then pivoted slightly toward the gallery. Those legal interns, junior attorneys, and compliance officers who had come expecting routine procedure and were now witnessing something entirely different. And if we let convenience replace due process, she said, her voice firm, we're not just failing the law, we're rewriting it, for the worse. She held Crane's gaze as she returned to her seat, the silence behind her echoing louder than any applause. The tribunal may have claimed discretion, but Pam had just reminded them of its limits. And now, the room waited for what they'd do next. Crane's silence was deafening, His authority, so absolute when he first walked into the room, now hung by a thread. His pen tapped once, then again against the wood of the bench, a nervous rhythm that betrayed the calm he was desperate to project. Reyes remained composed beside him, but even she was no longer shielding him with the silent approval she had maintained earlier. Pam had done more than present a legal argument. She had stripped the pretense of control from the room. The observers knew it, the city attorney knew it, and most of all, Crane knew it. With no tangible evidence, a precedent stacked against him, and a ruling already entered into the record, his options were rapidly vanishing. He cleared his throat. "This tribunal will take another brief recess." The words were brittle, a delay tactic, a way to stall the inevitable. But no one in the room mistook it for strength. They saw what was happening. The collapse of control. Pam didn't move, didn't smirk, didn't gloat. She simply folded her hands over her notes and waited. Control didn't always belong to the one with the gavel. It belonged to the one who knew when to speak, and more importantly, when to stay silent. And right now, silence was its own kind of dominance. When the tribunal reconvened 10 minutes later, Crane's demeanor had changed. The crisp authority he wore earlier had softened into something stiffer, more mechanical. His eyes didn't meet Pam's. Reyes, still seated, offered no expression either way. An arbiter observing the end of a match she had been invited to control, but never managed to command. Crane cleared his throat once more. "Miss Bondi," he said, voice clipped, "you've presented compelling argument. However, this tribunal maintains that enforcement under Clause 17A is procedurally sound." He paused, perhaps hoping the repetition would make it so. Yet, upon review, the evidentiary standard required to uphold the penalty in this specific instance has not been met. Pam blinked once. That was it. He was giving in without ever admitting defeat. Crane tapped the gavel once, quickly. "The fine is hereby overturned. Tribunal adjourned." A ripple of quiet motion swept through the room. Papers shifted, chairs creaked, but no one spoke. There was no outburst, no applause. Just the collective awareness that something important had just happened. Pam stood slowly, her expression calm, her breathing even. Crane had lost not just a case, but control of the narrative, and in doing so he had proven the very point he'd tried to deny, that unchecked authority doesn't break with noise, it fractures under pressure, one deliberate word at a time. Pam gathered her papers without hurry, slipping them neatly into her folder as the room slowly emptied around her. There were no handshakes, no congratulations, just quiet recognition in the glances of a few attorneys and observers who understood exactly what had unfolded. She had walked into a hearing and walked out, having dismantled a judgment, a power dynamic, and a system designed to silence dissent. The energy in the room had shifted, not with celebration, but with something heavier. A quiet reckoning. She didn't need applause. The silence was confirmation enough. As she approached the tribunal exit, a voice called after her, "Miss Bondi!" She turned to see Senior Arbiter Reyes approaching, her heels clicking softly against the marble floor. Her robe moved like a shadow across the tiles, controlled, deliberate. Reyes' face was unreadable, but her eyes held something more nuanced. Respect mixed with a trace of warning. "You were never supposed to win today," she said quietly, her voice barely above a whisper. This wasn't just about Clause 17A, it was about compliance, about showing others what happens when someone like you pushes back. Pam folded her arms, steady and unshaken. "I figured as much." Reyes glanced back at the closed tribunal doors before stepping slightly closer, her tone shifting from neutral to personal. "I wasn't brought in to observe, I was brought in to contain." The words hit like a second verdict, one with far more gravity, the kind that couldn't be overturned. Pam nodded slowly, unsurprised, but the weight of confirmation always felt heavier than suspicion. "So what happens now?" she asked. Reyes didn't answer right away. Her eyes scanned Pam's face, maybe searching for weakness. She found none. "You'll have eyes on you, and not just from this building." She didn't elaborate, and she didn't need to. The message was clear. Pam had upset something bigger than a single tribunal ruling. She had shown that power could be challenged and, worse, that it could lose. In a system that relied on obedience dressed up as order, that kind of disruption didn't go unanswered. As Reyes turned and disappeared back into the tribunal, Pam stood alone in the hallway for a long moment, absorbing the truth of what had just been said. The fluorescent lights above hummed softly, and distant footsteps echoed through the corridor, but everything else felt still. Then, with a steady pace, she pushed open the heavy courthouse doors and stepped into the bright San Francisco sunlight. The sky was sharp and cloudless, the breeze brisk. The fight was over, but the war, she knew, was only just beginning. As Pam walked down the courthouse steps, the city's hum surrounded her, honking cars, distant conversations, the clatter of heels on pavement. But her mind was elsewhere. Today hadn't been about a fine or a clause. It had been about reminding a room full of decision-makers that real power doesn't come from titles or gavels. It comes from understanding the rules well enough to challenge them. Power was clarity in the face of manipulation, precision in the face of intimidation, and as she disappeared into the crowd, one truth lingered. Compliance is expected. Resistance, when done right, changes everything. The story of Pam Bondi's tribunal battle teaches a powerful lesson about the true nature of authority and the courage it takes to challenge it. At its core, it reveals that power isn't defined by who holds the gavel, wears the robe, or enforces the penalty. It's defined by who understands the rules well enough to question them. Pam didn't win because she raised her voice. She won because she raised the standard. In a system designed to reward compliance and punish resistance, she reminded everyone in that room that due process is not optional. It's foundational. The lesson is clear: never mistake silence for agreement, and never assume that a decision is final just because it comes from a place of authority. When rules are twisted to serve convenience instead of justice, the strongest thing anyone can do is speak truth with clarity and precision. Pam's victory wasn't just about overturning a fine. It was about exposing a dangerous precedent and restoring balance. It reminds us all that justice only works when people are brave enough to demand it, even when the odds and the room are against them. True leadership, after all, is found not in dominance, but in disciplined defiance.